This is Mary Ann Thompson, President and Founder of Going Global. Great to have so many of you on the call this afternoon, joining us for the presentation on hiring international talent, visa tips for U.S. employers. Some of you are actually employers. We greatly are honored to have you as our guest for this presentation this afternoon. Little background, 2 sentences worth on Going Global. We are not only the industry leader worldwide, but also oldest vendor in the market for the last 25 years, providing location and industry-specific career and employment resources, all that have been developed in country by our various employment experts, designed for both U.S. students remaining in country, international students studying outside their home country, get a lot of usage from study abroad, alumni, etc. So Going Global, as I said, very honored to both sponsor this afternoon's presentation and have you here. The comments, the sharing of the latest in visa information regulations this afternoon, that part of the presentation will last about 40 or 45 minutes. You are welcome to put any questions that come to mind in the chat box or the discussion box. A lot of times we get more questions than we have time to answer. The good news is our 2 immigration attorneys, who you'll learn more about in a minute, are happy for you to connect with them gratis at no charge to learn more about a particular question you might have. Mark and Crystal will be providing their direct contact so you can reach out via email, or they even give you their cell phone number. It's quite an amazing, generous offer on their part. So let me tell you a little bit about our experts. Mark Rhodes and Crystal Malik are well-recognized immigration attorneys with the Immigration Practice Group at McCandless Holton. They work with companies and universities throughout the United States, successfully processing thousands of work visas and green card applications each year. Mark and Crystal frequently collaborate with colleges and universities to counsel staff and students on the latest guidelines for successfully navigating the U.S. immigration process. Mark has been repeatedly recognized as one of the best lawyers in America for immigration law, while Crystal has been highlighted as one of the best lawyers in America, ones to watch. So with that introduction, I'll turn over the presentation to Mark and Crystal and let us hear from them about the latest regulations and how they can better inform you on the process. Mark?
All right, well, thanks very much. As Mary Ann said, my name is Mark Rhodes. I'm here with my law partner, Crystal Malik, and we are both immigration attorneys. What that means is we work with companies, organizations all over the United States, helping them process work visas and permanent resident green cards. Our office is actually based in Richmond, Virginia, and although we're based in Richmond, we have 10 immigration attorneys in our practice, and we work with organizations all over the United States, ranging from gigantic companies that have thousands of employees down to very small startups. And one of the things, I've been practicing immigration law for about 30 years, and we've processed, 50,000, 60,000 or more H1Bs and permanent resident green cards over the years. One thing that I've learned is that many employers in the United States don't have a clear understanding about how the immigration process works. So what we're going to try to do here in the course of the next 40, 45 minutes is to give you a helpful roadmap for how an international graduate of a U.S. university stays in the United States and gets a work visa to work after graduation. Pop back to the last screen for just a second. And I think that some of the most helpful information is up here on the screen right now, because as Mary Ann said, Crystal and I will answer questions for free. So if you walk out of this session this afternoon and you forget all the information we've given you, or if your particular question is not answered, feel free to send us an email, give us a call. We're happy to answer your question. And we do this, we answer hundreds and hundreds of questions every single year from US employers, from career services offices, from international students. So feel free to keep our information handy. I think it's a very useful resource. All right, Crystal. Let's go to the screen that has the path, maybe 2 forward. One more. Yeah. So here is, so I can tell you that in the 30 years that I've been practicing immigration law, this is the typical path that I see that most international students follow to stay and work in the United States after graduation. Now, there are other options that may be available, but I can tell you that for about 95% of every international student, this is the path that they are going to follow to stay and work after graduation. Step number 1 in this path is for the student to get what's called optional practical training. So most international students are enrolled at universities in an immigration status called F1. All visa categories are designated by letters and numbers. For international students, just happens to be called F1. And F1 students are automatically eligible after graduation for up to 12 months of what they call optional practical training, OPT. Optional practical training will allow that international student to work for any employer anywhere in the United States doing any job, as long as the job is related to their degree program. So optional practical training is the best way, in my experience, for an international student to get their foot in the door with a US employer. It is the best way for a US employer to hire an international student to evaluate whether you want to pursue that international student further. So optional practical training is a great way for them to get their foot in the door. Every F1 student, every international grad in F1 status gets 12 months of OPT, optional practical training. If they graduate with a STEM degree, science, technology, engineering, or math, they will get an additional 24 months of optional practical training for a total of 36 months, 3 years of work authorization. And the employer doesn't really have to do anything. You don't have to file any paperwork with the government. You don't have to pay any fees to the government. As long as that international student has a little work card, it's called an employment authorization document, that student can go to work for you doing any job as long as it's related to their degree program. While they're working for you using their OPT, they'll want to talk to you about pursuing an H1B. So H1B is the most common work visa in the United States. And as I said, about 95% of every international student who is using optional practical training is going to want to try to get an H1B by the time their OPT ends. H1B will allow them to stay and work in the United States for up to 6 additional years. So they get their initial time frame with optional practical training, and then they get 6 years of work authorization using H1B. And it's typically during that 6 years of H1B that the international student, or at that point your employee, will want to think about pursuing a permanent resident green card if it is their desire to stay and live permanently in the United States. I'm not going to go into the mechanisms for obtaining a permanent resident green card in this session. We have had other sessions that deal with permanent resident green card, but this is the typical path that we see in our law practice that students follow to stay and work. First is optional practical training, then the H1B, then the permanent resident green card. There may be other options that are available, but about 95% follow that exact pathway. So let's talk a little bit about how to get that optional practical training work card. One more. There we go. So I would pop one more. There we go. So the first step for the international student to stay and work after graduation is OPT. Every international student will get 12 months of optional practical training. If you're in the STEM degree program, they get the additional 24 for a total of 36 months. The most important thing to remember for international students to take advantage of that OPT is that they have to get this work card. The second bullet point down, they have to get a work card. It's called an employment authorization document, an EAD. It looks just like a driver's license. The individual student cannot go to work until they have that card in their hand and the card is effective. You, as an employer, cannot put that individual to work until they have that work card in their hand and it is effective. In order for the international student to get that work card, they can actually apply for the card up to 90 days before graduation. And I usually encourage international students to apply as early as they possibly can to get that card. They don't have to have a job offer to apply for the card. They don't even have to have started looking for a job yet. They're automatically eligible to apply for that card as long as they're within 90 days of their graduation date. So I encourage them to circle their graduation date on a calendar, count back 90 days. That's the first day they can apply, and there is no reason to delay. Right now, it's taken the Immigration Service 90 to 120 days to process one of those cards. They can ask for expedited premium processing for an additional fee, but the easiest thing for them to do is just to apply for the card as soon as they can so that they have the best chance of having that card in their hand by the time they graduate and they are able to go to work right away. Let's step to the next slide. So for individuals who are in the STEM degree program, science, technology, engineering, or math, they're automatically eligible for an additional 24 months of optional practical training for a total of 36. But not all international STEM grads are going to qualify for that STEM extension. In order to get the STEM extension, they have to be working for an employer enrolled in the government's E-Verify program. E-Verify is this program that requires employers to electronically submit documentation to the government to prove that their entire workforce is legally authorized to work in the United States. Not all employers are enrolled in E-Verify. If you are an employer and you are not enrolled in E-Verify, your international student will not qualify for that additional 24-month STEM extension. You don't have to be enrolled at the time the person comes to work for you. If you have an international student working for you using that initial 12 months of OPT, and you want to assist them to get the additional 24-month STEM extension, you can enroll in the E-Verify program at any time. If you have questions about what that means or how to go about that, feel free to send me or Crystal an email, give us a call. We're happy to help out. Next slide. And let's be clear. Once the student has OPT, whether it's that initial 12 months or this 36-month STEM extension, there is going to be a clock that's ticking. And that clock is the end of their optional practical training. And at the end of their OPT, they will have two choices. They can either depart the United States or they can change to a longer term work visa. Most individuals are going to want to try to pursue a longer term work visa. Far and away, the most common option is the H1B. And I'm going to turn it over to Crystal to explain the process for getting an H1B work visa.
So when we've been talking about these OPT cards, at that point, the employer is not responsible for paying for anything. The student is allowed to file those applications on their own. They can pay for them, they can file them. They don't need any help from you except when they get to the STEM OPT period, right? At that point, they have to have a training plan and you have to be verified, but you still don't have to pay for anything. When we get to this H1B portion, that's where you start having to actually take the wheel. You have to take the driver's seat on these. This H1B work visa is the most common work visa for college graduates, and that's because that's what it's designed for. The H1B work visa is for applicants from any country, but who have a bachelor's degree in a specialty, and they have a job offer that requires that bachelor's degree. When we're talking about H1B, the employer at this point has to actually sponsor the employee. They have to have a job. The employer has to have a job that requires the degree. They have to be willing to file the application with U.S. Citizenship and Immigration Services, and they have to be willing to pay what's called a prevailing wage. And a prevailing wage is just basically what anybody in your locality for this job would pay for somebody with this amount of experience. There are government statistics that your immigration attorney is going to be able to help you find out what that prevailing wage is, but it's most likely going to be basically what you are already paying your employees anyway. At this stage, there's no reason to advertise for U.S. workers. You don't have to do that at this stage. You just have to prove that you want to sponsor this employee, and you have to be willing to take the steps necessary. All right. So with the H-1B visa, this is a longer term visa. When we talked about OPT, we're talking about everybody has 1 year, and then STEM graduates have an additional 2 years. With H-1B, everybody is entitled to a 6-year initial amount of H-1B. The employer sponsors for these in 3-year increments. If you happen to be an employer who wants to sponsor for a shorter period, that's going to cost you more, so it's not really a good idea. But that person's still going to be eligible for 6 years. You're just going to be filing your extensions more quickly. When you do H1, when we talked about OPT, right, these students can work for any employer on OPT, but when we move over to the H1B where you as the employer are actually sponsoring, then that student is now in H1B status, and they're only allowed to work for you as the employer, doing exactly what was described in the petition in the exact location that the petition disclosed. If they want to change employers, then the new employer has to be willing to file a whole new petition. And so it's kind of limiting, right? You filed this H-1B for this person. They're not allowed to work for anybody else under this H-1B, only allowed to work for the sponsoring employer. At this stage, like I said, the employer has to pay all of the fees. The base fees are what you see on your screen. There's the premium processing fee is an optional, completely optional, like speedy processing fee. It allows you to get a 15-day answer instead of a 3 to 6 month answer from U.S. Citizenship and Immigration Services. There are scenarios where the employee can pay this, where it's for their convenience, but that's the only fee that they're allowed to pay. The employer in an H-1B scenario has to pay for the attorney fees and all of the USCIS fees, and those do vary based on the size of your company.
And in terms of, flip back to the cost for just 1 second, Crystal, because many employers have questions about what the cost of the H-1B is, and there are basically 2 categories of cost associated with H-1B. First category is an attorney fee. Most companies don't have in-house expertise, so they hire an outside attorney like me or Crystal or another immigration attorney. In our office, we charge $3,100 to process an H-1B petition. And then there are the government filing fees. And as Crystal mentioned, filing fees vary depending on the size of the company. If you are a company that has 25 or fewer employees, there's 1 set of filing fees. If you're an employer with more than 25 employees, it's a different set of filing fees. But essentially, it is roughly $2,000 if you are a smaller employer with 25 or fewer. And it's a little more than $3,000 if you are an employer with more than 25. So it's my fee of $3,100 plus the government filing fee, and that's the total cost for the H-1B filing. I get many employers who will say to me, "Well, geez, I heard it was $10,000, $15,000 to file an H-1B." Well, if that's the case, I'm either charging too little or the employer's talking to the wrong attorney. Most attorneys charge right around what we do for H-1B filings.
All right. So when we file these H-1B petitions, we're also on a timeline. And that's why your OPT employees are going to start talking to you about this process really, really early. They know that this is a lottery system. There are only 85,000 H-1Bs available every single year. And more than 400,000 people applied for those slots last year. So what happens is that you end up with a lot more people entering than you have visas available. So every student knows that if they want to be able to get selected in the lottery at some point during their optional practical training, they need to try to get their employer to enter them every single year that they're able to be entered. So we're looking at a clock that starts right now, every single year in this 2 weeks of this 2-week period of March, where employers are allowed to enter their employees into the lottery system. So this year it's running March 7th to 24th. So if you happen to be somebody on this call who came on this call because they wanted to enter this year, somebody needs to hear from you tomorrow to get everything started. Because the system goes haywire on Monday, which is the last day of filing, and it closes at noon. And so we try to get all of our entries done by the Friday before, because on the Monday of, you're not sure you're actually going to get to submit anything because so many people are trying to submit that it overruns the system. So if you're one of the employers who has waited till the last minute, you'll need to contact immediately.
Yes,
Try to get this started.
as Crystal mentioned, this quota, the H-1B quota, there's 85,000 to become available every single year. It's just for new H-1Bs. So if somebody already has an H-1B, you don't have to worry about the quota. If they want to change jobs, you don't have to worry about this quota. If they want to get their next 3 years of H-1B, they don't have to worry about the quota. Only the very first time. So most university grads are going to be very worried about this quota. So the quota is released on October 1 every year. 85,000 H-1Bs become available, and every single year, all of them are taken on October 1 because you can pre-register to get one of those quota numbers. And the pre-registration period, as Crystal mentioned, runs this year from March 7 to March 24. So we're about 5 days away from the end. If any employer that wants to try to do an H-1B for an employee has to file that registration during the registration period. The registration period will shut down on March 24, and the government will assemble all the registrations that were put in. And there will be way more than 500,000 registrations. There were more than 500,000 this past year, past March. So there are going to be many more than that in my estimation. Once they assemble all of the registrations, then they're just going to randomly count out 85,000 because that's the quota. Once they have randomly counted out 85,000, they will notify everyone by April 1 whether the case was selected in the lottery. So I'll turn it back over to Crystal. She's a little under the weather, so I'm afraid her voice may be giving out here.
I'm grabbing cough drops over and over and over again. So this quota, they're worried about it because they know that the more times that they can get entered into it, the more likely they are to get selected at some point during their 3 years, their 1 year or their 3 years of eligibility. The good thing is that some of your employees are going to have an extra shot because what they have every year is that 20,000 of the slots for the H-1B lottery are reserved for U.S. advanced degree applicants, people who have a U.S. master's degree or higher. So when they pull all of these things, all of these entries together, they separate out all of the people who have a U.S. master's degree. They try to do a yield protect. They select enough entries to try to yield 20,000 actual applicants. They take all of those master's degrees, put them back into the general pool, and they try to pick out enough entries to yield 65,000 applicants for the all other category. Now, what happens, as Mark said, is that they notify you by April 1st. If you are an employer who's already done this, you know that typically what they start doing is they start doing it the weekend before April 1st so that they can be completely finished on April 1st. And then they allow you a 90-day period to file the actual H-1B petition. So we're in this period right now. There won't be another opportunity to enter again until next year in March. And these are all for an October 1 start date. Why October 1? That's because the government's fiscal year starts on October 1. So that's when the visas are actually released. But the regulations let them have people filing these applications 6 months ahead of time because they know that the Immigration Service takes months to process applications. So they allow that 6 months before October 1st, but they're all for an October 1st start date. We're going to talk a little bit about how this works with your graduation dates for your OPT employees, but understand that if you have an employee who is getting ready to graduate with a master's degree, but they'll have that master's degree conferred in the 90 days after they're selected in the CAP, you can go ahead and enter that employee into the advanced degree quota so they get that extra shot at the lottery. And let's say that you have a superstar bachelor's degree employee who's been doing internships with you during their time as an international student, and they're just getting ready to start their optional practical training, but they'll have their undergraduate degree by the time that they need to file it in that 90-day period after April 1st. You can enter that person into the lottery as well. That gets you 2 bites, right? That means that you're entering them the year before they start OPT. And then if they don't get selected the first year, then you can enter them again next year in the same lottery. So when we're talking about this calendar, what we're thinking of is, say that you have somebody who's graduating right now in May, they're going to apply for that first year of optional practical training for a May, June, possibly July start date. And so let's assume that they have a June 1 start date for their optional practical training. They're going to have a June end date for their optional practical training for that first year. So hypothetically, you could enter them in the lottery this year And if they aren't selected, they'll still have work permit that gets them to June of next year, which will allow you to enter them a second year in the lottery. So when your employee, right before they're starting or right after they're starting is really gung-ho about getting entered into this lottery, it's logical because they know how many entrants there are going to be in the H1B lottery, and they know that they may not get selected in their first, their second, or even their third year. Nobody's ever guaranteed to be selected in this lottery. And so the more times that they can be entered over the years, they can only be entered by you once every year, but the more times that they can be entered in a row each year, the more likely they are to hopefully get selected at some point during the registration. If you're in the middle of this this cycle and you have a June 1 start and June 1 end, they don't get selected the first year, but they get selected the second year, then what happens is that there's a cap gap relief. So they could have 1 year of OPT, they get selected in the lottery in April. You file that petition, but it doesn't start until October the 1st. Then what they're going to do is what the school is going to do is going to go into their school record, and they're going to extend their work authorization. There's a typo here. It's actually through April 1st of the following year now, because there have been so many extended processing times. But it's going to close the gap between whatever their optional practical training is and when that H1B is going to start. It's called cap gap relief. Same thing is true if you have a student who has a December graduation. Let's say that they graduated in December. They asked for a January start date to their optional practical training. They're only going to be working for you for about 2 months before they're going, hey, the H1B lottery is opening in March. Are you going to consider entering me in that lottery? That same helpful cap gap will apply to that. And also it'll apply to the degree. So if they have a master's degree that they're going to have at some point after this April 1st date, that'll apply there as well. But they are keeping an eye on this calendar, and we just want you to be aware of this calendar as well, because I've had a lot of employers who have wondered why the employee was so worried about this and hand-wringing and just very upset and beating them up about it. And it's because they know that if they're subject to this lottery system, then they're not guaranteed a slot. All right, so what we've been talking about is, for all of you for-profit employers, if we happen to have on this call any employers who are nonprofits, then it's possible that you might qualify for what's called an exemption from the H1B. It's cap exempt. It's from the H1B lottery. So the H1B cap exempt organizations are what you see on your screen. Universities are cap exempt. What that means is that they don't have to enter into the lottery. They can actually just file a petition directly with the Immigration Service any time of the year for as many employees as they want, and they don't have to worry about the lottery. If you're a nonprofit organization that's affiliated with a university, so we get a lot of applicants who work for social service organizations, who are nonprofit social service organizations and have a relationship with a university, or hospitals that are affiliated with universities, or school systems or private schools that are affiliated with universities. Those organizations, if they're nonprofits and they're affiliated with universities and we can document that, then they don't have to enter their employees into the lottery. The same is true for nonprofit research organizations and government, whether they're government or non-government research organizations. So if you think you might be exempt from the cap, it's definitely worth talking to an attorney to try to figure that out. Not all nonprofits are exempt from the cap, only nonprofits that meet one of the conditions that you see on the screen. So we spend more time on the lottery because the majority of employers are subject to that lottery. But if you think you might fit into this group, definitely contact us. We'd be happy to talk to you about it.
So let me jump in for some of these alternatives. So there are, as Crystal said, there are some organizations that are exempt from this H1B lottery process. Not very many, but there are some who are exempt. So what happens if you have an employee, they're working using their OPT and they're not selected in the lottery, and you're not one of those exempt organizations, you're for profit and you want to try to think of other visa options other than the H1B that may be available? Are there any? And the answer is not very many. If you have an employee who is from one of the countries listed on the top of this screen, Canada, Mexico, Chile, Singapore, and Australia, There are other options other than the H-1B that are excellent options, and I would encourage employers to pursue those. If you have an employee from one of these 5 countries, Canada and Mexico have a thing called the TN under what formerly was the NAFTA treaty. Now it's called the US-Mexico-Canada Free Trade Agreement. Chile and Singapore have a special H-1B category called H-1B1. There are quotas, but they never run out. Citizens of Australia may qualify for what's called an E3, very similar to the H-1B, also has a quota, but again, the E3 quota never runs out. So there are great options available to citizens of these countries. Another option that may be available if you happen to be a multinational employer, and that is a company that has operations outside the United States and operations inside the United States. You can hire an employee, place the employee outside the US for at least 1 year, and then they may be able to transfer back into the United States using an L1. There are no quotas for L1, but you do have to be a multinational company, and the individual has to work for you outside the US for at least 1 year. If you have questions about the L1, we process many L1s out of this office. Another option that may be available is an e-visa. E-visa is for citizens of certain countries that have treaties of trade and commerce with the United States. If there is a company in the United States that is owned by citizens of a country with a treaty of trade, that company can hire individuals from the same country. So, for example, let's say that Germany is a treaty country. Let's say there is a German-owned company in the United States. That German-owned company can hire German citizen employees to live and work in the United States using the e-visa. You can actually Google e-visa treaty countries to see what countries are eligible for the e-visa. This is also an excellent option for international students from a treaty country to open up their own business in the United States, because they can use the e-visa to sponsor themselves to open their own business if they're from a treaty country. Well, if you're not, if you have an employee, I mean, in the end, you have an employee who's working using OPT. If they're not selected in the H-1B lottery, if you are not a CAP exempt organization, and you don't fit into one of these alternatives up here on the screen, you're not a multinational, so no L, you're not a treaty country, no E, you're not from Canada, Mexico, Chile, Singapore, Australia, what options are available? Frankly, almost none. In most circumstances, students in that particular circumstance will simply re-enroll in a degree program, go back and get a higher degree, maybe get additional optional practical training. Perhaps during their degree, they can take advantage of a work program called curricular practical training. But in the end, the options are very, very limited for international graduates of US universities if they do not get an H-1B. And the H-1B quota is very frustrating for students. It's very frustrating for US employers. Just the fact that there are over 500,000 employers that register for the H-1B lottery and there are only 85,000 available indicates that the demand for H-1Bs far exceeds supply. Congress is not going to take any action. They haven't changed this quota for many years. So it's important to understand how the quota works. And I think we've provided you with the information that you will need to try to take advantage of the H-1B registration process going forward. And with that, I'm going to turn it over to Mary Ann to answer questions.
Great. Mark and Crystal, as always, soberly informative. We've got a lot of talent that's come to study in this country, and not a lot of visas, but at least we've got the inside track now that we've listened to you. I have 2 questions. For the H-1B lottery, don't most H-1B quota numbers go to companies like Microsoft, Meta, et cetera?
Well, I get that question a lot. Is it truly a random lottery? And the answer is, in my experience, it is a totally random lottery. There's not set aside for citizens of certain countries. There's not a set aside for large companies. At least there hasn't been in the past. We don't know what's going to happen going forward. But there's no set aside for certain companies. There's no set aside for certain degree programs. It is 100% random. I've had PhDs working for very large companies not selected in the lottery, and I've had people who have work as tennis professionals for a very small club who were selected in the lottery. So it truly is, in my experience, very random.
Mark, you don't know who the members of that very small club are. I think that's what the scoop is. My other question is, if an employer spends the money, which seems like a reasonable fee, to file the H1B petition, what'll happen? Won't the employee just leave? And how can that employer make sure that that employee that they went to all the trouble to sponsor and pay for stay employed by them?
Yeah, I mean, and we get that question quite a bit, and I can tell you that over the years, this office has probably processed 50 or 60,000 H1Bs. There are certainly employees who do move to different employers, just like U.S. citizen. You may hire a U.S. citizen, train them up, and after 2 years, they go somewhere else. You cannot get reimbursement of the H1B fees and costs from an employee who departs. So you can't have them sign some kind of agreement saying they'll repay. H1B fees and expenses are 100% an employer expense. But I can tell you that in my experience, most H1B employees are relatively loyal, because what they want ultimately is for the company to end up sponsoring them for a permanent resident green card. So they're going to want to stay with you, show you that they're an excellent employee, so that they encourage you to pursue the permanent resident green card process, which is a discussion for another day. But in the end, there's nothing really necessarily to tie that employee any more than there is anything to tie a U.S. employee. We don't have indentured servitude anymore in the United States, so employees are free to transfer and move elsewhere.
Wow. Britt, those are only 2 questions I have. Have any questions come in through the chat box?
Yep. Can you explain a little bit who enters the applicants into the lottery?
So, yeah, so what we recommend is that you do have legal representation to enter someone into the lottery. The employer is the person who's entering the person into the lottery. The employer is the one who has to sign off on it. The employer is the one who has to make the lottery entry. But we do recommend using an attorney to do that, to make sure that the employee is going to qualify and that the job is going to qualify, and to avoid any issues in the future with the actual petition that you have to file. So what happens is that you have to actually enter the employee into the computer. It's a fairly simple entry system, but the information has to be exactly correct. If you accidentally enter the employee more than once, then all of the entries will get canceled. If you try to enter for more than one entity and it's not a bona fide job offer, you're going to have an issue. So there's just a lot of little pitfalls that you can get into if you try to do this on your own. So we do really recommend that you use an attorney to do it. So the attorney would actually put the entry in for you and send it over to you for approval on the online system. So the employer is doing the entering, but having representation to make sure that everything's going to go okay with that entry.
And part of the reason that so many employers will register during this registration period is that the cost of entry is relatively low. We charge $500 to do an H1B registration during the registration period. The government filing fee is $215. So it's a relatively small investment to register in the H1B lottery system. If the case is then selected and we do the full H1B petition, that's where our fee is $3,100, and the government filing fee varies depending on the size of the company.
Great. And who is responsible for proving the job is directly related to the student's degree?
So this one's a STEM question.
Go ahead, Crystal.
The person who put this in put it in as a STEM question. So there are 2 different times that you have to prove that the degree is related to the job. Mark was starting to talk about the H1B process. For the H1B process, it's going to be the employer, right? You're going to be filing proof and documentation with the Immigration Service that shows that the job requires a bachelor's degree and that the student has it. For this STEM field for the STEM OPT, that's where this question came in into the chat. And if you want to enter questions into the chat, do that now, because we only have 3 in here, which is an aberration for these presentations. On the STEM OPT, it's going to be on what's called a training plan, an I-983 training plan that the student and the employer fill out together, and that gets submitted to the International Student Office for the student to be eligible to file for that STEM OPT. It's going to be a really, really short form. It's just a little box where you describe the job duties and how they relate to the actual STEM field. So it's pretty straightforward, pretty simple. Some people do use attorneys for that, but my experience is now we're several years in, and the majority of employers and students do that on their own. But it's really, really direct, pretty easy to do. And the student and the employer work together on it.
Great. So how do OPT students successfully navigate the perm process later when they have no previous experience before working for the company?
Yeah, so this is a much deeper question that doesn't really have to do with what we're doing today. You'd probably want to do a full consultation and kind of send us the information, the background on it. What a lot of employers end up doing is, if the job has changed over time and you can show that the job is more than 50% different, then experience with the employer can be used for the perm process. If not, we've still had success in the perm process where the student had very limited experience before being hired by the employer, just because these are such high needs areas that these perms are being filed for. But this is definitely something you'd want to do in really in-depth consultation to kind of parse through the facts of your specific situation.
Yeah, the perm is the first step in the green card process. So you'll have an employee working for you using H1B. The employee wants to pursue a permanent resident green card. The first step is called perm, and that is where the employer has to advertise the job offered to see if there are qualified U.S. workers. And in crafting those ads, you put in what the job qualifications are. You can't put in qualifications that the individual doesn't have, because you're not going to be able to pursue the perm afterwards. So if you have somebody who you hire who has absolutely no experience in your job ads, you can't require experience because you hired this person when they had no experience. So trying to navigate the perm process for a truly entry-level position typically takes legal representation.
Brett, any more questions?
Crystal, do you want, should we expect the October 1st, 2025 quota to be smaller than in years past?
No, it's set by statute and regulation. It's going to be the same this year as it has been for many, 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 many years. It would take an actual act of Congress. It's statutory and regulatory limited. They would have to actually do immigration reform to change it.
There still are legal processes in the United States. Not everything can be changed by royal edict.
Brett, any more questions?
That's it.
Okay. Well, the good news is you'll be getting a follow-up email from Going Global if you have been part of this discussion this afternoon. It will include a link so that you can access a recording of the presentation. This is a lot to take in, so I suggest you listen to the presentation again at your convenience. For those of you who are students and staff of our Going Global resources, you're welcome to listen to all the presentations have been recorded on OPT, on H1B, on green cards, lots of relevant information there. Of course, we've provided you with Crystal and Mark's direct contacts. You're welcome to reach out to them to clarify any additional questions that you might have. If you lose their contact information, feel free to contact Going Global again. And as a final reminder, I encourage Again, the students and staff at the colleges and universities who are Going Global customers, join Going Global for a training session. We've got a lot of new resources, especially cultural resources, training certification resources in the cultural arena that we'd like to share with you and tell you more about. So on behalf of Mark and Crystal, always our heartfelt appreciation for your time and talent, the sharing thereof, and to the entire Going Global team who worked hard to facilitate this presentation. So thanks to you all. It's a beautiful spring day, 80 degrees in Mobile, Alabama. The azaleas are blooming where I am, so hoping it's just as nice where you are. Signing off, have a great day. Goodbye.